Are we here? Working? I hope so. Welcome. Ladies and gentlemen, welcome to the Court Gallery. It is Friday, December 12th, 2025. I am your lone wolf Usul, and I come to you with a huge gathering of judges tonight. We're going to start off in Kansas with Judge Crum, quickly move to Judge Webster. Then we're going back into Michigan with Judge Rossi, staying in Michigan for the rest of the night with Judge Middleton and Judge Simpson for some landlord-tenant matters like we always have on Friday. Ladies and gentlemen, it's a wild one tonight, and we surely get to learn the weight of the gavel when it comes down. I am your lone wolf Usul. I am your humble host. Welcome to the Court Gallery. It all starts right now.
Good afternoon. Are you Logan Bunch?
Yes, sir.
All right, we'll go on the record in State of Kansas versus Logan Michael Bunch. Case number 25 CR 536. The state appears by Jared Regier. Mr. Bunch appears in custody from the Butler County Jail. You're here for a first appearance. There are 4 charges. All alleged to have occurred on December 11th, 2025 in Butler County, Kansas. Count 1 is a charge of aggravated domestic battery. Alleged victim, Josephine Camacho. That is a level 7 person felony. Count 2 is a charge of interference with law enforcement, a level 9 non-person felony.
What does that mean? How did I interfere, if I may interrupt?
The allegation itself reads that you did knowingly obstruct, resist, or oppose any person authorized by law to serve process in the service or execution, or in the attempt to serve or execute any writ, warrant, process, or order of a court, or in the discharge of any official duty.
So, I have a question on that.
Okay.
When they had detained me, I'd asked the officers multiple times can I please have my phone so I can contact my attorney? And they denied me multiple times on video, on their body cam. I asked them, I just want to call my attorney and consult with my attorney before I answer any questions.
Okay, but I don't want to get into the facts of the case.
No, yeah, you're fine, sir.
I need to advise you what you're charged with. You'll have an opportunity if you want to visit with an attorney about all of that and what your options might be. You'll have an opportunity to do that. That opportunity just is not at this time. This is just to let you know what the charges are.
Yes, sir.
So, count 3 alleges that you unlawfully, knowingly, and unreasonably caused or permitted a child under the age of 18, initials KXC, to be placed in a situation in which the child's life, body, or health may be endangered. That is endangering a child. That is a Class A person misdemeanor. Count 4 alleges that you did unlawfully, knowingly, and without legal authority restrained KXC to interfere substantially with that person's liberty. That is criminal restraint, and that is also a Class A person misdemeanor. So those are the 4 charges against you, Mr. Bunch. Do you understand what the charges are?
What? What's criminal? What is that? Criminal restraint.
I just read it to you. Do you need me to read that again?
Please and thank you.
All right. It alleges that on or about the 11th day of December 2025 in Butler County, Kansas, Logan Michael Bunch did then and there unlawfully, knowingly, and without legal authority restrained another person, to wit, KXC, so as to interfere substantially with such person's liberty. That's the allegation against you.
But what's that mean? Like, to withstand such a person's liberty? What does that mean?
I don't know what the facts of the case are, but essentially it means you held somebody against their will.
All right. Well,
so there is a felony or 2 felonies involved, so you're not going to be asked to enter a plea today. This case has been assigned to Judge Hart. Your next court date will be on his felony preliminary hearing control docket on February the 2nd at 2:30 p.m. Can you afford to hire an attorney to represent you?
I mean, I'll take an attorney you guys offer me now until I can hire an attorney myself.
Okay, well, if you can't afford an attorney, one would be appointed for you. Are you saying that you cannot afford to hire an attorney?
At this point right now, no, I cannot.
Okay.
That's what I'm saying.
So you wish to apply for a court-appointed attorney?
Yeah, but I can fire him though, right? And then go with
you can hire whoever you wish, but I need to determine if you qualify for court-appointed counsel. Are you currently employed?
I'm unemployed, yeah.
You are unemployed?
Yeah.
How long has it been since you worked?
Well, it's been a long time because I just got out in August, and I just got all my literally just got my ID, my social, and all my stuff now to go get a job. I haven't had those documents for a long time, sir.
You got out of where?
I got out of jail in August.
All right. I'll appoint James Watts to represent you. He's an attorney here in town. They'll provide you with his contact information. We need to set a bond. Mr. Regier, what's the state's recommendation for bond?
Your Honor, the state's information is that pursuant to paragraphs 1, 2, and 3 of the affidavit, it is alleged that the defendant punched, kicked, and choked the victim, ultimately requiring the intervention of multiple third parties, as well as laying the hands on a minor child who was present inside the residence at the time of the incident, besides at least one prior failure to appear in January of this year. The state understands this is a defendant with a history of felony convictions that the court may consider relevant, besides at least one non-person felony, felony flee and elude, felony criminal threat, and felony aggravated battery. It is also the state's information that this is a defendant who is an A on the grid. Therefore, the state is seeking a high bond with a very strict no contact order of at the very least $15,000 cash or surety.
So my bond will be $15,000?
No, that's just what the state's recommending. I'm the one who's going to set that, and I haven't set it yet.
Okay, and I also have a question. That failure to appear, I got out of jail and I was never issued no court date. I was in prison or whatever you want to call it. I'd been released, and I had no information of having a court date, and that's new to me. So can I ask what the failure to appear is for? Because I've seen the cops multiple times. I've talked to them multiple times, and they've never arrested me on any type of bench warrant or warrant.
All right. I don't, Mr. Regier, does your file indicate when or where that failure to appear may have been from?
One moment, Your Honor. In response to the court's inquiry, Sedgwick County by the state's information, Your Honor.
All right. Yeah, what town do you live in, Mr. Bunch?
Andover.
Okay. How long have you lived in Andover?
My mom's been there for, I want to say over going on like a year and a half since not this last August, but the August before that.
All right. I'm going to set bond at $200,000 cash or surety. As a condition of bond, you're to have no contact with any of the endorsed witnesses in the charging document.
200,000?
That's correct.
Don't you think that's a little crazy?
No, I do not. I think it's appropriate based on the charges and the prior history.
He say 15, which is 15,000 cash or surety. You went from 15
That was a
to 200,000.
recommendation. That's the bond that I'm setting, Mr. Bunch.
I can't even reach that. So that's against the statute of limits. Like that's against the statute of liberty.
You can visit with your attorney about that, and if you can get the assigned judge, who's Judge Hart.
I'm good.
Have a good day.
$200,000, bro. Bro, I'm gonna be sitting. I'm not even gonna get to see my kid be born, bro. This shit is nuts. Can I feel bad?
Sir, it'll take a minute for Miss Camacho to come in because they had a no contact order.
Very good, thank you. Are you Josephine Camacho?
I am.
All right, the information I have in front of me shows that the state has not filed charges at this time. Is that correct, Mr. Regier?
That is the state's information that there is not an information presently before the court, Your Honor.
All right. No charges have been filed against you at this time. Ms. Camacho, that doesn't mean that charges won't be filed in the future. If you leave a good address there at the jail, if the state does file charges, they'll attempt to send you a summons to appear if they do file charges at that address. If they don't have a good address for you, they'll likely issue an arrest warrant. Do you have any questions?
I don't.
All right. If you don't have any additional holds, you should be released this afternoon.
Thank you.
Do you have any questions?
Thanks.
All right. You are excused. Thank you.
Thank you.
Very well, we are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This matter comes on for evidentiary preliminary hearing this 12th day of December 2025 in case number GW 2025 CR 48, State of Kansas versus Keenan, Dwayne, Barrett. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Keenan Barrett, who appears via Zoom for supplication counsel.
We have a number of witnesses for the state present pursuant to subpoena. The preliminary hearing is concerning the felony charges. Count 1, failure to register as an offender. Count 2, same. Count 3 and 4, the same. Each level 6 person felony. Mr. McClendon, you said you're ready to waive the hearing on those?
Yes, Your Honor.
Very well, then, Mr. Keenan Barrett, I need to cover some legal ground with you on the record. The court being advised that the defendant wishes to waive his right to a preliminary hearing. Ms. Gillette, does the state wish to waive its right to preliminary hearing?
No, the state does, Your Honor.
All right, Mr. Barrett, I need to determine that you understand what it is that's being waived and the consequences of your waiver. I've explained to you what the felonies are, both at a previous hearing and this morning, and I know your attorney has too. At a preliminary hearing, as your attorney may have told you, the state of Kansas has the burden of producing evidence to make it appear that each of these felony crimes has been committed and to show probable cause that you committed each of these crimes. A preliminary hearing is not a trial to determine your guilt or innocence or not guilty. It's a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to require you to stand trial, or in other words, be bound over for trial. At a preliminary hearing, you have the right to be present with your attorney, and you have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention, or in your case, for further bail, as to the felony charges. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you would be required to meet if you stood trial. If you waive or give up your right to preliminary hearing, however, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You'll be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the charges against you, both the felony and the misdemeanors. Until that time, you will be released on your appearance bond, and you'll continue to be obligated to appear under the terms of that bond. Now, have you talked with your attorney about waiving your right to a preliminary hearing, Mr. Barrett?
Yes, Your Honor.
You need any more time to visit with your attorney before we proceed?
No, Your Honor.
And after hearing what I've had to say, do you still want to waive your right to a preliminary hearing?
Yes, Your Honor.
Are you voluntarily waiving this right?
Yes, Your Honor.
Has anyone made threats or promises to cause you to waive your right?
No, Your Honor.
Are you in good health today?
Yes, Your Honor.
Taking any medications which might impair your judgment today?
No, Your Honor.
Mr. McClendon, do you know of any reason why the court should not accept the defendant's waiver?
No, Your Honor.
Very well. And Ms. Gillette, you said the state is waiving its right as well?
Yes, Your Honor.
The court therefore finds that the state of Kansas has waived its right to a preliminary hearing. The court further finds the defendant has made a knowing waiver of his right to preliminary hearing after consultation with counsel. It is the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. And Missy, when will that be?
This case will go to Judge Satterfield, and she is available February 12th at 11.
That date work for counsel, February 12th at 11?
That works for me, Judge.
Ms. Gillette?
Will that be, do you know if that'll be in person?
It's by Zoom.
Okay.
All right. That is by Zoom. Ms. Gillette, if that works for you.
I'll be with Judge Satterfield all day.
Okay. All right. So, Mr. Barrett, you will need to be here by Zoom before Judge Satterfield, February 12th at 11 a.m. for arraignment. And I'm going to make it a condition of your bond. I'll continue your bond with the added condition that you reappear as just directed. Any questions about that for the court, Mr. Barrett?
No, Your Honor.
All right. Make sure Mr. McClendon can find you between now and then if he needs to.
Yes, Your Honor.
Okay. Thank you, sir. And the rest of you that have been here for subpoena, thank you for honoring those subpoenas. You may have had to testify, but by the defendant's waiver, we will not have the hearing. And unless Ms. Gillette tells you otherwise, Mr. McClendon?
Yes, Judge, I wanted to be heard on bond before we logged off.
Oh, okay. All right.
Let's go, please. Deputy Fisher needs to get back to training.
All right, Deputy Fisher, you can go back to training unless you need him, Mr. McClendon, on the issue of bond.
No, Your Honor.
Mr. McClendon may go. Ms. Gladden can go. Was that the name? Cole Gladden. You may go. Or you may stay if you wish. Same with you, Mr. Barrett, Michael Barrett. Okay, go ahead. You want to be heard on bond, Mr. McClendon?
Yes, Judge. My client's family lives in North Carolina, and I have an address and such, and he would request permission to be able to go visit his family over Christmas. It'd be from Christmas Eve to January 7th. A specific address can be provided. He's talked to his bondsman. His bondsman said as long as it's good with your parole officer, he is on parole out of Lyon County. said as long as it's good with the parole officer, he's good to go. Parole officer said as long as it's good with you, he'd be good to go. So everybody's kind of passing the buck to you on this. So we would request to be able to go home. He hasn't seen his family in, I'd say, approximately 6 months. He'd like to go see him just over the holiday and return to Kansas shortly thereafter.
Did I understand correctly that Michael Barrett is his father? Mr.
Yes.
Barrett? Okay, you're his father, and where do you live? Here in Kansas?
I live at my
The other Mr. Barrett, the senior Mr. Barrett. Where do
Yeah,
you
I
live?
live in Madison, Kansas.
Okay. And do we have a no contact between the two Mr. Barretts on the screen today?
No,
No? Okay. Would you be going back with him to the Carolina state, whichever, is it north?
no.
No. Okay. Ms. Gladden, are you a family member?
No, she's a
Okay.
CS she's a investigator from another agency where he was at when he left Kansas without deregistering, changing his address, or letting us know where his whereabouts were, and was still registered in Kansas. I believe she's from Tennessee.
Correct. I am from Tennessee.
That's
Okay.
where he had been when he left here.
So he's on some kind of supervision in Tennessee? I heard something about his parole officer. Where are you on parole? Keenan Barrett?
in Lyon County in Emporia, Kansas.
You're on parole for what up there?
I've been on parole for my very first charge, which was the aggravated sexual battery from 2015.
Okay. All right. So you've got a parole officer. That means you've been to the DOC?
Yes, Your Honor.
Okay. So you've got, they'll be looking for you if you don't come back. And your bondsman, you're on a 10,000 with Owen's bonding company in this case. Owen said they're okay with you going?
Yes, Your Honor.
And your parole officer in Lyon said they're okay.
Yes, Your Honor.
Okay, Miss Gillette, do you want to be heard on that issue?
Judge, this is a failure to register case. It had to deal with him going to another state without permission. I have concerns with him leaving to go to another state. Again, because that's what brought us here. So I would request that he stay in the state of Kansas.
Well, North Carolina isn't right next to us like Kansas City or some of those.
Judge, if I may.
Please.
So Mr. Barrett did face charges out of Tennessee. He was on probation for 2 years in Tennessee and completed the probation there. This case does stem from back in 2022 or 23. I'm a little fuzzy on the dates, but he has had a significant change in his demeanor, and I do not believe he's a flight risk at this time. And again, he can provide the address as to where he's staying to the court if it would bring the court a peace of mind.
What were the charges that put him on the registration list?
It is aggravated sexual battery, Your Honor.
And
That was from 2015.
what made it aggravated? The age of the victim or the incident? The nature of the incident? Do you know that?
I don't know that, Your Honor.
Ms. Gillette, do you know that?
I do not have his original conviction. I can look it up.
Well, I think it might make a difference to me if he's a threat to children. Of course, if he's a threat to women, or men, whichever. You said, I've got to think about the community, whether it be Kansas or Tennessee or North Carolina. But he's been on parole for apparently how long, Mr. Barrett, have you been on parole?
I'm on lifetime parole, Your Honor.
Oh, you're on lifetime parole.
And Your Honor, if it makes a difference, my parole officer has given me permission over the last 2.5 years to visit, and I've registered and all that. I could prove to the courts that I would register 2 days before and in North Carolina just so I could visit my family. I'm on top of everything. I'm just trying to see my wife and kids, honestly.
How old are your children?
So I have a 14-year-old son, I have a 21-year-old daughter, and then I have a 22-year-old son. And me and my wife are currently married. We have actually been together for almost 7 years now.
But you haven't been home in Christmas between the prison time and that sort of thing. Is that what's been keeping you from seeing your family?
No, it's this charge in Greenwood County.
Well, this charge isn't more than 3 years old, 3.5. So
Well,
you're saying you haven't been home in 3.5 years?
When you guys put this charge on me, this warrant got put out on me, I had just gotten back from North Carolina. So I literally came and turned myself in, and I haven't been back since.
Okay, and I think that Ms. Gillette suggested that you hadn't registered when you came back from North Carolina.
He hadn't registered when he left for Tennessee.
Ah, okay. Well, shoot, Mr. Barrett.
I mean, I'm to do an ankle bracelet if I have to, just to prove to you guys that you can trust me. I'm willing to do anything you want me to do so I can visit my family.
Ms. Gillette, your thoughts on an ankle bracelet? He'd probably have to hook one up in Kansas and another when he crossed the line, and there's going to be multiple states in between us.
The new versions have a GPS locator that's based on a mobile device, and it'll track where he goes as long as it's within cell phone service.
Well, that sounds more reassuring. The cell phone service would be aware, through the cell phone service, they'd be aware of where he was at all times. Mm-hmm. They'd know if he stopped at a convenience store or something like that, or if he stopped at a school grounds, they'd know that. And
yeah, it'll track him by GPS everywhere you go.
Does that make you have any more thoughts, or you want to stand by your previous position?
If he's on GPS, then I know he's back for his hearing.
Well, you've got the I wouldn't consider it, but for the fact that he's got Owens bonding that would go after him, and the Department of Corrections would go after him, I would think, or Lyons County, whichever does that when they're on parole.
Yes.
Well, Mr. Barrett, I am not real crazy about your proposal. I can appreciate your desire to be with family, especially at the holiday time. I have some concern, though, about the nature of the registration requirement and facts that are allegedly bringing you here before me. But as long as you have, I want to see something in writing from both the Owens bonding agent and the the parole supervisor, Mr. McClendon, if we can get that, saying they're okay with it, that they'll go get him if he doesn't come back. Of course, he'll have new charges, absconder charges, if he doesn't come back. And if he can have that GPS, the modern version Ms. Gillette says is available.
Where would I go to get that?
Green Feather Monitoring or Butler County Monitoring.
Okay.
Do I go to like a courthouse in Eureka or?
No. Where do you live? Are you in El Dorado or are you in Greenwood County?
I'm in Emporia.
Well, I don't know Emporia enough to tell you what's available. I do know. You might just Google electronic monitoring in Emporia. I've never worked in Emporia legal system, so I don't know what
your
they
bondsman
have.
Your bondsman can probably tell you.
Excellent idea. Thank you, Mr. McClendon. He's probably right on the money. Start with your bondsman.
And then the numbers to the two different places that I know of too, and he can communicate it to his client.
Okay. So you want to give him to the bondsman or Mr. Keenan Barrett?
I'll send him to Mr. McClendon. He can send him to his client. I can't communicate with the defendant directly.
True. Well, you can right now, but through it with his attorney present. But yeah, I understand. All right. Mr. Michael Barrett, do you know of any reason why it would not be a good idea to let him go down there?
Nah, he'll do what he says he'll do.
Okay. And
I guarantee you that.
okay. Miss Gladden, I don't know totally what your relationship is to him other than you've apparently had some contact. Do you know of any reason why he shouldn't go on this visitation?
I've not dealt with Mr. Barrett since his time here in Tennessee. During that time, he wasn't totally truthful about where he was going to be, but other than that, I've not had a lot of contact with him and haven't in several years now.
Well, that's a pretty big issue that you're not where you're supposed to be. Because that's what this charge involves, you not doing what you're supposed to be, not telling everybody where you were. You understand, Mr. Barrett? Right now, you need to make sure you keep people advised of where you are, such as your bondsman and your parole officer.
I will, Your Honor.
You could pick up a new charge of absconding, and your attorney can tell you about the consequences of that if you don't come back. So you want to be gone through January what? 7?
It's Christmas Eve to the 7th of January.
And your plan would be to leave which Carolina North?
Yeah.
Okay. Well, I want your bondsman and your parole officer to know exactly what your schedule is, when and where you'd be, and I want you to give your attorney here, Mr. McClendon, that same information. Mr. McClendon, make sure that the county attorney has that as well. But you definitely have to have that GPS that will tell us where you are at all times.
Yes, Your Honor.
And I'm going to order that I don't know what happened in the other county, but don't be alone with any potential victims, such as children or alone with any one individual person.
Yes, Your Honor.
Make sure you're in the group. Good. All right. Don't make me regret doing this, Mr. Barrett, please.
I won't, Your Honor.
If you don't keep your word, you're going to have to face me again someday, and you don't want to have to do that.
No.
Not for that reason. All right. So, Miss Gillette, can you journalize how specific I want this? I want a real specific. Do you have any questions of me, Miss Gillette, what you need to journalize on that?
I put down that he may visit his family in North Carolina with GPS monitoring on the type of mobile.
And he's not to be alone with anyone under 18 or anyone who fits a description of his victim in the other county. I wish I knew more about it, but that's all the best I can do.
Yes, Your Honor.
And don't violate any laws, Mr. Keenan, Mr. Barrett.
No, thank you.
Okay. You get that GPS on before you even leave.
There's a mouse in that jacket.
There's a mouse in your jacket. I don't want to know about
Sorry, I just saw a mouse climb up my coat, Your Honor.
Oh boy. You mean a real mouse? Okay, I'm going to let y'all go so he can go deal with that mouse. You behave, Mr. Barrett.
I will.
Thank you all for being here.
You're welcome.
Kent County Circuit Court is now in session. The Honorable J. Joseph Rossi presiding. We are here in the matter of the people of the state of Michigan versus Nicholas de Bruin, case number 25-01966-FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on defendant's motion for resentencing. I would invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
Good morning, Your Honor. Don Birch appearing on behalf of the defendant appellant Nicholas de Bruin, who is on Zoom at MDOC.
Very good. Thank you, Mr. Birch. And Mr. Birch, this is your motion. And Well, let's take it one step at a time here. First, you contest the scoring of offense variable 1 on the explosive device, arguing essentially, as I also heard at the sentencing hearing, that this was a firecracker, not, improvised explosive device like might have blown up in Iraq or something, and thus, didn't create the level of danger that would justify OV1.
Yes, thank you, Your Honor. Your Honor, I saw the transcript, but now my argument is OV1 is aggravated use of a weapon. And what I cited in my brief, the Random House Webster's College Dictionary, it defines a weapon. Any instrument or device used for attack or defense in a fight or in combat. And I think that's critical. I mean, there was no fight, there was no combat. And then again, I just ask you to reconsider that sometimes these scoring guidelines can really be inflated if something is not scored correctly. Now, once again, nobody was outside, and I just still think that if nobody is outside, nobody was exposed to harm or danger. And Your Honor, that's all I have on OV1. That's my argument there. I think it should be scored as 0, Your Honor. And Your Honor, this is huge too, because if it was scored at 0, his minimum guidelines would be 12 to 24 instead of 29 to 57, which is a big gap.
Well, I agree that it's significant. Ms. Burks, your response on OV1.
Your Honor, the people have nothing to add aside from the brief that we submitted.
All right. Well, regarding OV1, I did consider this at the time of sentencing. I think it's acknowledged by both sides that the device or explosion that was in this case was essentially one or more commercially available, at least somewhat commercially available fireworks. And I do have to note here, I remembered from being a kid where the M80 is the top of the food chain in terms of your fireworks that you can get your hands on. You could get your packet of firecrackers, but those were relatively mild compared to the legendary M80, which was known to create the biggest boom of all fireworks, even when I was a kid, which is getting to be further in the past than I'd like to acknowledge. So, and notably, when I was a kid, they were all illegal in Michigan. You had to find a supplier who was willing to cross the border to Wisconsin and buy that stuff. At least I spent summers in the Upper Peninsula, and that's how I gained my black market knowledge of firecrackers and such. And so an M80 is a more powerful version of, or the most powerful, probably, a version of a firecracker. And accordingly, they're somewhat regulated. My research attorney did look up, what are the rules about M80s, and they're significantly more than you would find for example, your run-of-the-mill firecrackers. And of course, anyone that's been around those explosives knows that they can be dangerous if they're too close to you. If you hold on to it in your hand too long, there is risk that it exposes a person to say nothing of the very loud noise that it makes when it explodes. So, and I do think I appreciate the argument, Mr. Birch, but I go to subsection 2 in that Random House dictionary that you cited that says anything used against an opponent, adversary, or victim. So, no doubt here, this was, at worst, a attempt to intimidate, get the attention of, a former domestic partner someone who there was a relationship in the past. Undoubtedly, it's, as I said, it's not a roadside explosion in the Middle East. This is something less than that. However, there can be no doubt that the intention here, when this M80 or series of M80s is thrown out of the door of the truck, the intention, though perhaps not to injure, wound, kill anyone, was certainly to do what the M80 does best, make a great big noise that, would intimidate, scare, frighten the victim in this case, and not only had that effect as desired on the victim, but also, several of the neighbors around said, well, that, explosion was loud enough that it, rattled my windows. Therefore, I do find that the OV1 is scored properly in this case, even though, as I said, it wasn't a situation of a hand grenade or, a weapon designed to kill or injure the opponent. Thank goodness it was more something designed to make a loud noise. Well, it did that, and, there's also some testimony record that I think we're going to talk about in a minute about damage to a vehicle. The debris kicked up when the thing exploded did cause damage to a vehicle. And I note, as cited in the prosecutor's brief, that, I think the victim's father said, well, and I looked outside, you could still see the stuff falling in the air. This had the effect of intimidation, fright, etc. I don't think that the, weapon requirement in OV1 does require, anything further than that. I think that the fact that it is used to during the commission of a crime, and what weapons can of course be employed to kill and injure someone, but are very frequently used to simply intimidate or frighten someone, and that was the impact here. So I'm going to keep OV1 scored as it was at the sentencing. And we can move on to, I think, OV16, which I kind of grazed upon earlier, alleged damage to this vehicle.
And Your Honor, this is kind of interesting, but Your Honor, I have a current appeals. The application for leave to appeal was granted in one of your cases, so for example, that I know you're putting a restitution amount in here, and I think that restitution amount does hurt, again, clients, and it hurts the scoring. Now there was no restitution hearing, but now the way it's going is it leaves the appeals attorneys having to do the restitution hearing per se, and to me, it should be determined ahead of time that you have a restitution hearing and then you have sentencing, because without, just say we have the restitution hearing 3-4 months from now, and it comes back to only $200 to $1,000 damaged. well, now what do? Do you resentence him? But Your Honor, again, now, okay, there was repair. I don't know if it was one or two vehicles. And Your Honor, I just think that just as I stated that having it $3,000, I think $3,500 estimate, again, inflames the scoring at 5 points.
Nope, I do somewhat sympathize with you because it's not at all uncommon, and I try to get that restitution number out there as quickly as I can. However, I've observed in the plea and sentence process, it's not at all uncommon to, for example, have a defendant plead to, I'm going to make restitution in 3 or 4 cases, even though I'm only pleading guilty in one, and then I'll ask the prosecutor, well, what's that restitution? $200, $200,000, what are we talking about? And oftentimes, particularly at the plea stage, that number is simply unavailable. Now, usually, and at least my policy is someone's got to put something into the documentation that I get to satisfy that very low, preponderance, some evidence that is of the restitution due at the time of sentencing. And I've been, what kind of drives this from my perspective is also there's somewhere out there a decision of the Supreme Court that says, Judge, you can't say restitution is to be determined, at a later hearing. You got to give a number at the sentencing time, and that number then is subject to a restitution hearing, which it is every, and following, there's restitution, of course, is driven by statute. It's its own separate provision of Michigan law, and every defendant is entitled to a restitution hearing, whether they were, hit for $200 of restitution or, I had one defendant in here who tried to burn a tag off one of those security tags off a toy or something at Walmart and inadvertently set the entire Walmart on fire. The restitution, the contents of a Walmart, well, it turns out that's about $4 million. So poor guy, started with something that could have been that retail fraud conviction. And by the way, you're on probation for 3 years and you can start making payments at a monthly rate, till you pay down your $4 million of contents of the Walmart. So, it ranges, in other words, but what Michigan law very clearly says is that victims are entitled to restitution. The judge should make his best effort at least to set restitution at the time of sentence in a dollar figure, and I've occasionally when I've had a rare case where a defendant's there, but they can't put a dollar figure on it, I've assigned $1 or $2 nominal and said, you know what, defendant, come on in and you do the restitution hearing, or the victim, you do the restitution hearing if you want to set that amount. However, if I do have a dollar figure and the threshold there isn't very high, it's someone submits an invoice or something that says, hey, here's what I think I lost at the time of hearing, and that's what I want you to order for restitution. I set the restitution as the Supreme Court's directed in a dollar amount, not to be determined. And I did that, early in my tenure on the bench, and then saw that decision and altered my practice. So, so now I was put a dollar figure to it where there is restitution ordered. And my feeling is if I order zero restitution at the time of sentencing, then, that in effect, the victim is stuck at that point. They're going to come back and take another bite at the apple and say, Judge, I want you to add restitution because then I have to resentence. The defendant at that point is sentenced with no restitution. And of course, if it's to their detriment that, even if it's a smaller amount of restitution, I think there's a good argument to be made that, every case like that would have to be resentenced. So I guess defense counsel, appellate counsel, and I are caught in the same, web here of kind of the way criminal procedure shakes out in these restitution cases. So in this particular case, there was a document provided and it was for repair to a vehicle, and that's where the restitution number came from here. Now, and I'll note also in the nature of sentencing, there isn't much time. I frequently have defendants counsel stand up there and say, Judge, we think that restitution number is out of line, way inflated, and my usual cure for that is, let's set a restitution hearing, and they're entitled to that, of course, at any juncture, from a week after they're sentenced to, what we're doing now, significant amount of time after sentencing, to contest and finalize the amount of restitution. And, restitution hearings can be their own little 2-day long animal in the case of a multifaceted embezzlement case where, I had that where, insurance paid some of the money back. And so there were offsets. It was almost like a civil damages case, trying to sort out what that restitution amount appropriately is. Now, this one's not that complex. I mean, the restitution asked for was property damage. It was to a vehicle, and there was an estimate for repair to the vehicle. Now, I glanced at that estimate again, and it occurred to me, well, is this a case of, that was damage that was caused by this explosion, or was there a little bit of damage caused by the explosion and someone took the occasion to detail their vehicle? Well, I can't tell that from, that's why we'd have the restitution hearing in the first place. But that is the cure here. And unfortunately, given the nature of procedure, I always encourage, attorneys and defendants when they contest restitution, hey, get it in. Request that restitution hearing. And I can understand in your situation, Mr. Birch, it may fall to you, even though you're, primarily working on the appeal here. You got to get this restitution. And on top of it here, it impacts this, the OV16 that is hinged to the value of the damage. However, I don't see any other way to do it. So I will grant a restitution hearing. You can request that. We'll present proofs. And if, they're at the hearing, the amount came in at less than $1,000, which certainly could in this case, then I would revisit the scoring of that offense variable. But for now, I'm going to leave it the same because I do find that the prosecutor made their I said very low threshold of initial proofs in establishing the amount that I set at restitution. All right, let's move on. The final was the question of boot camp. Was this a sentence that where there was a term or condition that he would get or be eligible, in taking the plea deal? Also, and I don't think the boot camp, and really that's a decision, in the way the statute and DOC procedure works out, that entirely falls to me as the judge. I have never, at least in my now coming up on 9 years on the bench, seen the prosecutor weigh in on boot camp or not. That happens post sentencing after. In processing at MDOC and determination of eligibility. And my understanding, again, I'm not going to claim intimate familiarity with MDOC's requirements for boot camp. Obviously, there are charges that will never be eligible for it, but this, I wasn't certain that this was one of those. And then I have learned over the time that, if I send someone to MDOC for more than 36 months, then they're not going to be eligible for boot camp. So, in some respects, that 36-month sentence, is tailored to preserve that, at least that portion of the eligibility. What's the, from your understanding, Mr. Birch, what's the holdup here, or what's driving the ineligibility for boot camp?
Well, Your Honor, it says it in the statute, if one is eligible for a boot camp, and what he was convicted under, he is not. And
I see. Just that the statute or the offense itself would never be eligible for boot camp.
Yeah, that's correct. And that's what kind of surprised me. I'm not sure why defense counsel, nobody kind of picked that up. And And then, Your Honor, if I may, but Your Honor, I mean, I can understand that there was no agreement made. It was contemplated that he would get boot camp, but Your Honor, I just think the information presented to you, and then you said, okay, I'll keep it at 36 to make him eligible. But Your Honor, too, I mean, if he was eligible, then he might have only, whether it was 6 to 9 months, he might have only served in the MDOC. But now we're talking about that he's serving a 36-month sentence. And I do have one other thing I wanted to address, but I'll just wait.
Yeah, no, and I again, with the boot camp determination, I harken back, it was one of those embezzlement cases. The guy had stolen over 6 or 7 years, almost $1 million from his employer. Employer is like infuriated, of course, and wants the guy locked up for, and thrown away the key. And of course, even though I did send him to prison, the guidelines weren't that bad. And I get the tag back, and the guy's eligible for boot camp. Now, this guy's not a violent offender. He's an embezzler. Yeah, he's got a college degree. He's got a felony, conviction for embezzlement. Now he's not. The employer said, "Yeah, he's going to go work for one of my competitors doing the same thing." And I said, "Boy, your competitor, not too bright if he hires a guy with a felony embezzlement." But I'm not a business expert either. I wouldn't do it, but maybe some risks are worth taking. But so he qualifies for boot camp, and then I get a letter, just infuriated from the employer saying, this guy's got a slap on the wrist. He went to boot camp. But my point being, in that case, is a nonviolent offender. Total no violence risk to society. Is there a risk he's going to steal some more money? Sure. But, my feeling, you got a felony embezzlement on your criminal record. Well, it's buyer beware if you hire the guy. So just odd how that works out. So that guy, he shortened up a couple years sentence by doing boot camp, as an accountant. I also tried to envision how that guy was going to fare in that boot camp environment, with a bunch of younger people out there, and the drill instructors yelling at him and such, because in my, and again, I don't have a very intimate knowledge of, I know there is eligibility, and I know SAI, which is what boot camps are referred to by Department of Corrections, is an alternate route where you get, what I like about it is it gives you some more intense preparation for return to the community in those classes, and that intense probation supervision you get when you're out on boot camp. However, we'll acknowledge not everyone's eligible for boot camp. And why one assaultive crime qualifies, probably the weapon here that, again, going back to that, that's the disqualifying element in this crime. Because I just had a kid, who was involved in a big fight in downtown Grand Rapids, couple kids visiting from Muskegon wound up going to the hospital, and I sent everyone to, well, not everyone to prison. I sent the three males that were the ringleaders there all went to prison, and I get back, the youngest guy who was only 19, he was kind of following his big brother who was on parole's lead, getting into this fight. Comes, hey, you're eligible for boot camp, and I'd made a big deal, to these guys about the severity of the crime and the black eye in the city and stuff. So I sense his big brother going back to MDOC for, he's also going for 3 years out of this fight. No jail credit. He was on parole, so he's going to do a hitch, and parole might flop him for some extra because I think he was in for carjacking. And but the younger brother, I get the thing, hey, he's eligible for boot camp, which I didn't expect because it was a pretty significant assault with GBH crime. I thought he wouldn't be eligible, so I let him cool his heels for another 6 months in the Department of Corrections, and then signed off on him going to boot camp because I thought, well, maybe this young guy can change things around like boot camp intends to do. But I'll be the first to say, all of the MDOC programs, including boot camp, are, there's no guarantee. The one guarantee in truth in sentencing is you're going to serve that minimum guideline amount on the sentence if your conduct in the Department of Corrections is good. That's the one guarantee that any defendant, can take out of the sentencing. And that's why, of course, we advise you the maximum sentence at the time of plea. And, we take a great deal of effort in fashioning the plea agreement so that, my feeling is, when a person agrees to something like that, they ought to have a pretty good idea of what it's going to come out to at sentencing. And for that reason, I try to make it clear that once I, cede jurisdiction to the Department of Corrections, I don't have any much ability to influence that. And in this case, I reviewed that record, excerpts of it, and, I did make it very clear that that was a determination made by MDOC and that I was crafting a sentence in the hopes that perhaps he'd be eligible, but that there wasn't, at the end of the day, that determination was up to MDOC after intake. So I don't think he was misled on it. He may have hung undue amount of hope on going to boot camp, because I totally get it. Boy, boot camp looks like 18 months and I'm going to be cooling my heels for 3 years. Judge, that's a lot different in the impact on my life. And it is. However, it also corresponds to the severity of the offense for all the reasons that I put on the record at sentencing. So though I sympathize that he's not eligible for boot camp, he was advised that that was by no means a guarantee at the time of sentencing, and I don't think it invalidates the sentence here. So in conclusion, I'm going to deny the motion for resentencing at this time.
I have one more thing, Judge.
Yep, go ahead.
Your Judge, I wanted to bring up to kind of clear the record, and then also clients always, want me to bring up things. But Your Honor, again, a sentence on inaccurate information. Apparently, it was his son that threw the firecracker, and his son was charged, but then the case was dismissed against him. I'm not really sure what had happened, but now I don't think that was brought up in sentencing, and then I wanted you to be aware of that, Your Honor. And then my client was not charged with an accessory to this, but I thought.
Well, and luckily for him, he wasn't charged with the manufacturing the explosive device either, because it wasn't ever clear to me. I think this was more than one M80, and of course, again, I was hearkening back to my childhood of how you could chain those things together with their fuses and make a bigger boom and stuff like that, which, I used to know about. I had no idea, and it wasn't crystal clear. What was crystal clear is the son was in the vehicle, and, I brought this up at sentencing. In my mind, it's one thing to be caught up in a domestic violence relationship and do it yourself. Whole different thing to drag your young kid. The same thing as I said to the big brother. I said, hey, your actions here have a ripple effect. And, you bring your little brother to something and he goes to MDOC for the first time. It doesn't just suck for you. It sucks for the other person too. And, and in this case, though the kid didn't experience any legal repercussions of this particular action here, I'm certainly not going to advocate for, involving a kid in a domestic dispute like this. And, as I said, to say nothing of setting a horrible example, you think about it in context of the kid's going out and exploring his own relationships in the world. And yeah, things go south. Well, you can always intimidate them by throwing some sort of explosive device out your vehicle window. And the fact that the kid was involved, well, to me, that was, an aggravating factor, that I considered it at sentencing too. So, and the kid throw it out the window, dad threw it out the window. Well, I was pretty darn sure, no one said, dad never said this was the kid's idea, and he duct taped me up and, brought me along on this as an unwilling participant. And just like I said to the big brother, hey, you're the oldest one. You're the one that should know better. At the end of the day, your duty isn't to stop in and, deliver the knockout punch. Your duty here, at least as far as I'm concerned under the law, is to say, hey, I'm the voice of reason. Let's put the brakes on this, situation before, people get hurt and people go to prison, et cetera. So, and if I said that to a big brother, I would say it to a dad with about 10 exclamation points behind it. The example you set for your kids and the things you show them to do have lifelong impact on them. And, that wasn't something that was spoken to in the sentencing variable, but, as a parent and arguably a voice of conscience for the community, I felt like that was an important factor. So, I get it. Dad didn't throw it up. It wouldn't have mattered to me, to me, at that point, the kid's acting as an accessory or arm of the parent, in that situation, if the dad's not, even if dad was going to deliver, a Valentine's card, $100 gift certificate to his ex, and the kid said, hey, what would really be cool is if I threw this M80 or series of M80s out the window and saw, show them, we can still make noise out here. I would expect a dad to reach over and say, no, that's a bad idea. Let's not do that. Let's just get out of here and, I'll show you how to catch fish or hunt deer or something else, but not do that. So, I get it. Kid was involved, but it isn't a plus for the defendant in this case, in other words. And I think we got everything we need for today. So I appreciate the arguments, but like I say, things going to stand as they currently do. And Mr. DeBryan, I know it's a longer term in the MDOC than you anticipated. If you were hanging all your hopes on SAI, all I can tell you is, when you're in MDOC, just like when you're anywhere else, you're faced with a series of choices. And those choices include, you can get involved with, restorative justice groups or educational opportunities that are in there. I know they got some vocational training at the vocational village, or at least they did before we redid our state budget. I hope it's still there. And, but I know you got to make some effort to get involved with that. And of course, you got the other choice too. You can get tatted up from your eyebrows down to your toes and join a white supremacy gang while you're in there and, chart that future for yourself. I would obviously advise you to take option A. Gives you a lot better choices when you get out, and has a lot more potential for positive influence on your life. And take the time to reflect on, hey, this was a screw up, but as I said, I send people to prison for screw ups all the time, and sometimes it's for 25 years or more. And this isn't that kind of screw up. This is a setback in your life, but it's not a life ender. But your goal, and the moment you walk out of those gates, whether whenever it is, should be never to return there. Or at least that would be mine if I were in your position. So, and they do have some resources, but I know you need to send up a lot of kites and kind of be the squeaky wheel to get that attention and get that. But, I'd encourage you to utilize the positive stuff that's in there, however long you wind up serving for your time. So with that, we're concluded.
And I thank you, Your Honor. If you could put me in a breakout room with my client, and then also prosecutor, I'll send you the proposed order.
Thank you.
Okay, thank you, Your Honor.
I'll get you in a breakout room right now, okay?
Okay, thank you, Ms. White. Appreciate it.
You're welcome. Next is the people of the state of Michigan versus Jose Aguero, case number 19-05982-FH. This hearing is being recorded on Zoom and live streamed on YouTube.
Right. And is this also a bond motion for Mr. Aguero?
No, this is set aside.
Set aside. Okay, very good. And there I go. I see that's in older file that I have. All right, this case comes before the court today on a application to set aside 2019 domestic violence conviction. I invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
Good morning, Your Honor. Tyler Velo, P number 75702 on behalf of Mr. Aguero.
Very good. Thank you. And I did receive a memorandum from the prosecutor's office indicating that the crime qualifies as an assaultive offense or serious misdemeanor, and that they do not believe that he's eligible because he's already used up the lifetime maximum of 2 assaultive offenses set aside. And they cite Michigan Compiled Law 780.621, subsection 1B, for that rule. I'll toss it to you, Mr. Villio. How do I get around that if we can?
Yes, thank you, Your Honor. So, as you indicated, the prosecutor, but also the Attorney General, opposes the application citing MCL 780.6211B, which limits lifetime set-asides to no more than 2 assaultive crime convictions. The AG, as you indicated, counts as 2 prior set-asides, both for assault with a dangerous weapon, as exhausting this cap, rendering this 2019 conviction ineligible. Respectfully, this court should reject that interpretation. The 2002 convictions arose from a single suicide attempt involving self-harm with no third-party victim. So these do not qualify as assaultive crimes under the statutory definition, which require an offense against a person. Granting the set-aside aligns with the rehabilitative purposes of Michigan's expungement laws and promotes public safety by removing barriers to Mr. Aguero's reintegration. I would like to take some testimony from my client. He will testify today that those 2 convictions in 2002 resulted from a suicide attempt where he attempted to set himself and his dwelling on fire. He was convicted of 2 counts of felonious assault and arson and malicious destruction of property. So, but again, critically, no third party was assaulted, threatened, or harmed. The assaults were self-inflicted. Any perceived endangerment was incidental to the self-harm, not a targeted act against others. And so the legislative intent of protecting the safety of the public and the safety of others, denying this application would fly in the face of that. My client was experiencing a mental health episode. This was a long time ago. He has lived a very successful life. He's close to getting his master's here, and he's going to be working at his master's in social work, and he's going to be working at the MDOC. And my client, of course, would love to tell you about the exciting things that he's doing with his life.
Very good. Well, let me swear in Mr. Aguero, and we can proceed. Mr. Aguero, if you can unmute, please. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Can you unmute?
You're going to have to hit that red microphone button that might be at the bottom of your screen somewhere.
And Your Honor, my client's legally blind, so he may need just a minute.
Not a worry. It looks like he's got it.
Yep.
Did I do it right?
Yep, there you go.
Yeah, let's try that again with swearing you in. If you'd raise your right hand.
Yes, sir.
Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Very good. You may proceed, Mr. Villo.
Thank you. Mr. Aguero, can you explain what happened in 2002 that led to your conviction of 2 felonious assaults, arson, and malicious destruction of property? What was happening there?
Yes. At that time, I was working at a racetrack as a security guard, and I had my own place, my own car. And I recently went to renew my driver's license, and I found out that I had a degenerate eye disease where I'm going to be completely blind. I should also add that all my life I've been hearing impaired. So what was going to happen to me was I was going to be completely blind and deaf within a couple of years. And after I fell into a serious depression, went to a medical doctor, they put me on 3 different types of antidepressants, and not much later than that part, I ended up losing my job, my apartment, my car. I moved in with my abusive parents, and I just fell apart. I didn't want to live anymore. And then one day when everyone was gone, I decided that I wanted to end my life by setting myself on fire. I went and got some gasoline out of the lawnmower, put it all over my clothes. And as I was doing this, my mom came home and caught me, and I told her what was going to happen. She left the house, called the police, and the police came, and I told them I didn't want to live. They tried to tell me that life is worth living, and I didn't want to live. And then eventually they tried to kick down the door. And when they were trying to kick down the door, I was holding the door, and I lit the match, and it fell into the garbage can that I had next to me because it had paper. And I was going to jump on the garbage can and set myself on fire that way. And by the time I was able to do that, it happened so fast. They kicked down the door. They knocked me over. I grabbed the kitchen knife from the kitchen. I went in the backyard, put it up against my neck, and I said I didn't want to live anymore. I told them to shoot me. And eventually they, I surrendered, and they put me in the car. And eventually I got charged for arson and assault and all these other stuff at that time.
And so, Mr. Aguero, since that time, what have you done to show that you've been a productive member of society?
Well, I would love to share that with you, with everyone. I'm actually what you call a deafblind person. I'm not completely blind yet, and I'm not completely deaf, but I'm deafblind. And there's only 70,000 of us in the whole entire country. There's 330 million of us, and only 70,000 are deafblind. And out of the 70,000 that are deafblind, only 2% go to college and get a degree, but there's a 90% dropout rate. Well, I'm one of those people who made it past that. I'm at a master's program. I completed the MSW, Masters of Social Work program. I have 1 year left. I have to do the internship hours, and I'm going to start in January at KPEP, which is the Kalamazoo Probation Expansion Program. And I will be a facilitator for the substance abuse disorder counseling group for the parolees and probationary people. I just completed my internship at Kalamazoo Defender, which is a public defender's office. And it's also a resource for the community, that deal with the houseless, the disabled, and also, parolees or people who are going to court. And this has been a long road for me. This has been like an 11-year journey, and I'm almost done. I have 3 semesters, and then I'll be able to move from disability to actually being a professional product, a person who can produce in the society, and I'll be able to support myself securely for the first time since I've been blind and deaf.
And Mr. Aguero, where were you planning on working? I'm sorry, I may have missed that.
Oh, KPEP. It's in Kalamazoo. Yes, it is Kalamazoo Probation Expansion Program. They're part of the NDOC.
Have you had any negative contact with the police since 2019?
I have not.
Do you have any pending charges, or are you currently the subject of any police investigation that you're aware of?
I have not.
Okay. All right. Thank you, Your Honor.
All right. And Ms. Burks, do you have any questions for Mr. Aguero?
No, Your Honor. Unfortunately, I don't have any information about the incident that Mr. Aguero testified to. So I would just rely on the brief that we already submitted.
Very well. No, thank you. Well, I have reviewed the record here, and basically, Mr. Aguero's counsel asks me to consider the circumstance here, and of course, of the prior conviction, in that, under Michigan law, of course, the prior conviction that was set aside involved both arson and felony assault with a dangerous weapon. 2 counts of that looks like that were set aside arising out of that incident, which are, of course, assaultive felonies, and I believe arson's also an assaultive felony in the state of Michigan. However, counsel, encourages me to consider the circumstance of that earlier conviction, in that it was in effect a failed suicide attempt by arson, where though, and arguably mom was endangered by the attempted arson, police officers are endangered when they encounter that situation. However, it's not your classic assaultive offense where, it starts as an attempt or effort to cause injury, intimidate, etc. This started at the end of the day as a suicide attempt and was fortunately thwarted by the mother and police officers before Mr. Aguero was able to end his life. So I would find under those circumstances that the characterization of that particular series of offenses as assaultive under Michigan law, though legally correct, is not supported by the facts that Mr. Aguero testified to today, indicating that it was a failed suicide attempt. I can easily see, after all, attempted suicide itself is not a very common charge. In Michigan, the charge usually reflects the actions taken, but isn't exactly an exact match. So I will find, therefore, that doesn't eliminate his eligibility to set aside the current conviction, and further, that his accomplishments since that conviction warrant that, in that he has obtained additional education despite his which is deafblind is a profound disability. There's no question about that, and also that the folks with disabilities certainly benefit from education, and particularly a good example like Mr. Aguero, who can come out and say, look at, even though you got these setbacks that life hands you, you can overcome those. So Mr. Aguero's a shining example of that. Very familiar with the KPAP program, sent many men and women down to their women's program in Kalamazoo, and I always have been a fan of the program and the results, some of those folks have achieved. So I think that would very much benefit from Mr. Aguero's work. They're facilitating groups and, kind of putting his own life experience, ups and downs and encounters with the criminal justice system, to work in a positive way to help out other people. So I will grant the motion at this time. I will set aside the second conviction, finding that factually the first is conviction, though, viewed in the most strict technical light, is an assaultive crime. The facts don't support an assaultive conviction on the first one that was set aside. I'll grant it to set aside the second.
Thank you, Your Honor. We really appreciate you taking the time to listen to our case today, and I'm sure Mr. Aguero appreciates it.
Nope, you did a nice job of working that up, and that, lightning rarely strikes like that. I'm kind of bound by the statute, but I also know that there is some room for judicial discretion in there, and this is one of those rare cases where I actually have the chance to apply it, and can't think anyone more deserving than Mr. Aguero. So congratulations to you, sir. I wish you the best of luck helping out the good folks at KPAP.
Yeah, thank you, sir. Appreciate you.
Thank you, Your Honor. Have a great holiday, great weekend. Thank you, Your Honor.
Are we done? Or hello?
We're all set.
We're all set.
I'm all set. Thank you, Your Honor and prosecutor.
Yeah, I will send out the order, and Mr. Aguero takes sometimes it can take up to a month to 5 weeks or so for the state police to remove it from lien. If you need to prove to anyone in the meantime, you can just show them a copy of my order setting it aside.
Thank you, Your Honor. I appreciate that very much.
My pleasure. Pleasure to meet you, sir.
Yeah, thank you.
Elaine, I don't have the Memory Lanes versus Autumn Molot file. Shows it's on here, but I don't have it.
I'm here, Your Honor. It should be on the agenda.
It is. She's here. It shows it's set for 9:10, and I don't have the file. Let me make sure I didn't clip it to my last file, which I've been known to do. I've got it right here. I did clip it to my last file. So, Elaine, I found it right in front of me. Mr. Stuart Weiner is here on behalf of the park. Let's see who else is here.
Yeah.
Chris Corpany, our manager, I believe. All right, Ms. Molot is the only one here, so I guess we'll just start with advising her of her rights as a tenant.
Okay.
And we may have to do this more than once. Good morning, Ms. Corpenny.
Good morning, Your Honor. Good morning, Stuart.
Ms. Molot, they have filed a motion to terminate your tenancy. I want you to move.
Yes.
As a defendant in such a proceeding, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to assist you. They're usually with us for these proceedings, but our legal aid attorney, I believe, is on vacation. So you have the number to contact legal aid, or you could seek other legal advice. You have a right to have the case. Say that again.
Where would I find the contact information?
It should be in with your summons and complaint.
Okay.
Anyway, we'll make sure that you find it.
Yeah.
Okay. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use the jury demand form and pay the $50 fee, unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted from property because you haven't paid rent, that is a different circumstance. In this case, they're simply asking you to move. They wish to terminate your tenancy. You may be able to reach an agreement with the landlord by going through mediation, or you may be able to reach an agreement with the landlord that means the case will get dismissed, in which case they could file what's known as a conditional order of dismissal.
Okay.
They are moving to terminate your tenancy. They served that notice to quit on you on August 18th. And is this lot and trailer?
I own the trailer.
All right, so this is a screwy one. Mr. Wiener, what's your position here?
So, Your Honor, and I have Ms. Sharpening here to answer any further questions. Apparently, there was an agreement to rent the lot, and have possession, but she did not identify another person who was living with her. That created the first problem. She violated the agreement that she had signed for her tenancy. And then this person has created problems in the park. Police have been called on a number of occasions, and we have received multiple tenant complaints. So I think Ms. Sharpening tried to address this issue with the tenant, but to no satisfaction, and so we have to regrettably...
Is that person Ronnie Lee Miller?
Yes, Your Honor.
He's in jail right now for assaulting Miss Molot. He was, maybe just got out on a bond. Anyway, he's charged with assaulting Miss Molot, and he is set for sentencing in the near future. Miss Molot, what's your position?
On I'm unaware on my position on what, Your Honor.
Well, they want you to move your trailer and go.
Yeah.
They're evicting your trailer. And the one difficulty is there's nowhere to move a trailer to.
Yeah.
So what's your position?
I am not sure. I was thinking about if it did come, like if they, if it was a moving situation, then I would have to sell it because the trailer is rather old, and it has some structural problems. So I don't think I would be able to move it.
It is an option in the just cause termination. It says you have 10 days to sell or move the mobile home.
Yes,
and
sir.
Most of our currently cited mobile homes are not movable.
Yeah.
A, they're not movable, and B, there isn't anywhere to move them to.
Yeah.
But because of these incidents with your boyfriend, they're wishing to terminate your tenancy. So you're getting a double whammy. I think he was charged with stalking and domestic assault.
Yes, sir.
And now, because of him, they want you to move.
Yes.
He currently has a bond condition that he's not allowed to have any contact with you.
Yeah.
Ms. Corpening and or Mr. Weiner, does that affect your position, knowing that the source of the problem has been charged with crimes against her?
I doubt that, Your Honor. Ms. Sharpening, what do you think?
Well, I never had a problem with Autumn in the past until Ronnie moved in. I'm willing to look at it and have a conversation with Miss Mowat. As long as he's not coming back, I'm willing to consider that.
Okay.
But he can't come back. He's created a real problem in the mobile home community.
Yes, sir.
He did 30 days jail. And he's on a probation with some jail hung over his head. No contact with victim until further order of the court. All right. Well, let's continue this a bit to give you an opportunity to discuss this. He has been released from jail within the last day or two after doing 30 days. He's on probation, and one of the conditions of his probation is he's not allowed to have any contact with Miss Mowat.
Does that include telephone calls or just physical contact, Your Honor?
No contact whatsoever.
Okay.
All right. Miss Molot, who else lives there? Do you have kids there?
Yes, that's me and my daughter, or me and my 2 kids.
Well, we're coming into the holiday season, so we've got some missed court dates. But we are available next Friday, the 19th. We're probably going to continue all these till next Friday, Mr. Weiner. Okay. So let's see how that works for you. The 19th.
Let me check. The 19th works for me, Your Honor.
The day is crammed full. 10:30.
Okay. I can be available.
Ms. Molot, I would suggest you've got a couple options. You may contact legal aid. There may be some defenses to termination of tenancy when you're a domestic violence victim.
Yeah.
There may also be able to set up an agreement with the park that if he's not there, that you can stay, in which case they could work out something called a conditional order of dismissal. So okay. I would suggest that you contact Ms. Corpening and discuss that with her. Okay. Now, Ronnie's not supposed to have any contact with you, and if he does, he's in violation of your probation. So don't let the camel get his nose under the tent. Don't let him call you. Don't let him stop over there. A, it violates his probation, and B, it's going to ensure that you get evicted.
Yeah.
So stop in today or early next week and talk to Ms. Corpening about this, and then she can discuss it further with Mr. Weiner.
Okay.
All right, thank you. You're good to go.
Thank you so much.
Okay, thank you, Your Honor.
Just call the case Stylopharm versus Tyler Crowe.
Cindy Fontanella for the plaintiff.
Hello.
Hello.
You can come up to the podium here. What's your name?
Tyler Crowe.
Okay, you need to take hands out of your pockets. All right. How much is currently owed?
Your Honor, I'm showing that there's rent due of $3,215.23, court costs of $190, for a total of $3,405.23 due.
Sir, how are you intending on getting that paid?
I can pay $1,000 today, and then $1,000 over the weekend when my cashes or clears, and then by next week I can pay the rest.
By next week?
Yes, sir.
So you can get the rest paid, are you saying by the 19th, a week from today?
By next Friday, yes, sir.
By the 19th. So today's the 12th. I just want to make sure I'm hearing you correctly.
Yes, sir.
You can get everything paid by then.
Yes, sir.
All right. So here's what I'm going to do. I'm going to grant a judgment for possession, finding no tribal issue after a hearing on this case. So I'm going to grant them that judgment. I'm going to, so your normal writ date would be the 22nd. I'm going to make it the 23rd. Okay. So you're going to be able to get everything by the 19th, but I'm giving you basically until the 23rd. Give you an extra few days, get all of that in, make sure.
Okay.
In case there's a hiccup, okay?
Yes, sir. I appreciate it.
Okay. And that's $3,405.23. That would include everything.
Yes, sir.
All right.
Absolutely.
But I'm going to suggest to you if you got the 1,000, get it into the landlord.
How would I? How do they want me to pay that? Through cashiers, or can I pay through the website?
I don't. Is your portal closed?
I believe so. Yes.
All right. So you're going to have to get a cashier's check and get it into them.
Okay. Thank you.
Okay.
Have a good day.
You too. Stylopharm versus Maria Emlosa.
Cindy Fontanella for plaintiff, Your Honor.
Oh, there she is. Miss Emlosa? Can you unmute? Oh, there she goes.
Okay, here I am.
Hello, how are you?
I'm doing much better, but it's too cold.
It's too cold?
Yeah, I don't have heat, so that's why I didn't come in person, because I haven't been sleeping well.
Okay, I'm sorry to hear that. Okay. You got somebody coming by to deal with your heat? But this is
so far I saw the case yesterday. And
you did what?
What'd you tell me? I guess information where to get help. So as soon as I finish talking here, then I'm going to call them to see if they can help me with the heat.
Oh my gosh. Mr. Noza, how long have you been without heat?
Since last year when I was going through with nothing, I didn't have heat. I applied with SER DHS, and I never had anything. So I don't know. And that's when, things started, not working for me. So I was like, you know what, God will provide. So yeah, I'm alive. I'm thankful. I can't complain.
Bless your heart.
Yeah.
Okay. How much is owing on Miss Emlosa's account?
Your Honor, before I do that, I just want to make it aware, the court aware, this is an owned home owned by Miss.
Yeah, no, I know.
Okay.
I know. That's why I didn't ask why you guys haven't done anything.
Okay.
I understand that.
I just wanted to make sure. There is rent I'm showing, Your Honor, of $2,242.85. Court costs of $190 for a total of $2,432.85. She did make a payment of $1,000 on December 5th. That's posted to the account.
All right, that already posted.
Yes.
Okay. All right, Ms. Emlosa?
Yes.
How are you intending on getting the rest of this paid?
Okay, I met the caseworker yesterday, and today they called me to let me know that they sent the check is in the mail going to Stylopharm. Faith in Action is the one helping me.
So Faith in Action said, okay,
Yes.
how much did they say they were going to pay?
They didn't tell me because they wanted to look at the ledger. They go by what is on the ledger due.
Okay. And I'm presuming, Ms. Fontanella, you don't know anything about that.
I unfortunately do not have any information regarding assistance from Faith in Action, Your Honor.
Okay. All right. So, Ms. Emlosa, did you think they were going to get everything caught up for you? Is that what you think they were going to do?
They just, told me that they sent in a check this morning. It's already in the mail, going to Stylopharm. So I called Stylopharm, and the person, I think his name is Bryson, somebody. He answered the phone and he said he's the only one there. The people who handles that, they are all out of the office. So I asked the manager there. She said she'll be back Monday, because I wanted to know if they contacted, they were contacted by Faith in Action yesterday.
Got it. Okay. And
Your
they
Honor.
weren't able to tell you. Okay. Yes.
Patty is out of town this week due to a
Got it.
She'll be back on Monday, though, I believe. So we'll find out if she's had any communication or if they've received the check. I'll understand.
Okay. Ms. Emlosa, I'm going to adjourn your case out a week. Okay.
Okay.
So I'm gonna adjourn it to the 19th, next Friday, 2025 at 2 p.m. Okay.
At 2 p.m.?
And that way
Okay.
we can try to figure out about that check and everything. Amy, is there utility assistance at all, or that you're
particular program, but I could maybe zoom in and try to speak to her in a breakout room back over here.
okay? Thank you, Ms. Emlosa.
Yes.
Okay, let me ask you this. Did your heat just get shut off because of a bill? Because I know you've been here to see me.
No, that is not with DTE. My faucet stopped working last year. Sorry, I didn't clarify on that. It's the faucet stopped working.
Your faucet?
Yes. I mean, in my furnace, I don't know. I think
Your furnace. Okay, your furnace stopped working.
Yes,
Okay.
that's the one. Furnace, yeah.
Okay, it's okay. Were you able to get somebody out to look at it?
That's what I'm about to do. When I finish court, I have to call Habitat for Humanity to send somebody to look at it.
Okay. All right. Here's what I'm going to do and let you give the whole story. I'm going to put you into a breakout room in a minute with Amy. Okay?
Okay.
And just talk to her, let her know what happened and where you are. And can't guarantee anything, but maybe there's somebody out there that can help you, okay?
Thank you so much.
You are welcome. All right. And, I don't know if it was the last time, but I think the last time I saw you, you were in the hospital.
No, I haven't been in the hospital. Thank God. I have not been sick. But on and off, yes, but not in the hospital.
Okay. All right. Well, I'm glad to see that you're doing better. Let's see what we can do for you, okay?
Yes, I'm doing well, and God bless you for your concern.
Okay. All right. So you just hang on the line there and we'll make sure that happens, okay? Momentarily.
Thank you.
You're welcome. Lightstone Apartments versus Christine Barrett. Yeah, upset.
So jury box is over here.
All right.
Again, J Big, and then J Big, P36820 on behalf of the plaintiff, and I have two property managers here from the facility.
All right. And where are we on this case? This is her motion.
Before we begin, I respectfully ask that my appearance be not recorded or posted online for myself.
Ma'am, that is the way I conduct the proceedings. And so I maybe understand your request, but this is an open court proceeding. And I view that as part of the transparency of the court. So if that's a motion before the court, that's denied. This is your motion. What would you like to say to the court?
So, you have my motion to set aside, a motion to modify or set aside the judgment. The judgment is based on a materially incorrect rent amount elected 1471, but plaintiff's own documentation lists my rent as 522. And no LIHTC income certification or rent calculation has been done in order to support the higher amount. Yeah.
May I see that first?
You folks can be. What is this you're submitting to me?
I'm submitting the shows my monthly rent.
Okay. All right. And go ahead with what else you were going to do. Ma'am, let me ask you this. There was a judgment taken for 7801.58 or 54. That was back in November. So as of November 7th, how much do you think you owe?
Your Honor, I don't think that has been, the right rent has been determined.
No, but you're telling me that the amount they gave me that day, and everybody was here, and I didn't hear that dispute.
Because I didn't have that information.
Have what information?
That document there, I didn't even find that until after. Because once
Okay, so hang on a second. So once you found it, how much do you think is as of November that you owed?
Your Honor, I think, would you mind rephrasing that question?
Okay. You're claiming that the amount that they gave me for the judgment, which was not disputed at the time, of the $7,801.54, that was inclusive of their cost. That was in November. How much do you think you owed?
I believe that I owe less than that.
Okay, less than that, but how much less than that?
I'm not sure, Your Honor, because of the rent amount. It's not correct to me. I have two conflicting rent amounts. I have 1471 and 522.
Could I interject, Your Honor?
Yes, go ahead.
Yeah, to clear this up, Your Honor, the paper that you have before you is the prorated first month's rent. Yes, not the monthly rent. The monthly rent is 1471 per month. She's in what we call affordable housing, Mishta, and so the 1471 reflects the capped rate, and what she's presented to you is
what would have been her portion, and I get that. It would have been her portion plus the security deposit, and then she would have needed that amount to move in.
Right, and we had this discussion outside, and I asked her, so what do you think you owe? Give me a number. Would you be able to pay that number today? Because we're trying to get a writ of eviction due to the judgment. So whether if she has a reduced amount that she believes that she owes, the bottom line is that if she doesn't have the money to pay, how can she retain possession? But as you can see, Your Honor, the rent and the numbers that we've presented in the judgment reflect the 1471 monthly rent.
So what, ma'am, what happened to your subsidy?
There wasn't a subsidy. No subsidy. It's
LIHTC.
LIHTC, okay.
Held under certain obligations for rent rules. And also disclosures and regulations that weren't given to me. That determines how much I get, how much my rent is, and also there's also I'm sorry, give me a moment.
No, it's okay. Let me ask you this, man. If I said, and I'm not making this fine, but if I said, I'm going to find in your favor, and so I'm just going to say 50% of this you would need to pay. So that's going to be about 35 plus 4, so $3,900. And I said, that's what you would need to pay to stay. Do you have that?
I do have that, Your Honor, but I also would like the rent amount to be correct, because there's two conflicting ones, and under LIHTC, there's also conditions I don't know, it's a market rate. It has to be, it has to be certified through Modification and LIHTC. So it has to come with.
Where'd they go? Okay.
It has to come with an income certification, a utility.
Yeah, but ma'am, here's my point. My point is, you don't owe nothing.
I'm not saying that.
I know. And so what I'm saying is, even if I took the amount of the judgment and I cut it in half, you're telling me that you had that. Do I have anything in this?
Oh, did you finish? I didn't hear the rest of it. I'm sorry. Would you mind?
Yeah, I finished. If I said you need to pay half of this, when could you pay that?
I could probably pay that my next week's check. I don't remember what's it.
Well, hold on a second, ma'am. The problem is that when I'm dealing with these cases, you just need to be straight up with me. Because when I asked just now, I said, do you have that? And you said, I have that.
praise myself. I can't have that. Yeah, I'm not trying to give you a headache. I just want.
Ma'am, nobody gives me a headache. Well, my daughter, but nobody else gives me a headache. I just said that for her benefit. What I'm trying to figure out is, this wasn't a default. You were here on November 7th. Pardon?
I was here, but
Oh, I know. And that's when you brought up no dispute, and I entered the judgment.
yes, because I didn't understand what I understand now. I think the amount is inflated, and I don't believe that 1471 is the true rent. It goes off of life rules and regulations.
How much do you think is the true rent?
522, which is the document that you see in front of you. That's
Okay, and if it's 522, how many months haven't you paid?
3 months I haven't paid.
What 3 months are you talking about? Because I'm telling you, when they filed their complaint, you haven't, the last time you made a partial payment was in June.
And then I made a payment in October and November and on December. These were partial, some of these were partial payments because I reflected what I believed as the true rent. And I'm disputing it today.
A couple of those
I'm not
payments
saying-
bounced.
Pardon?
I believe a couple of those payments bounced.
She had a check.
There was only one.
Hold on. There was
Check she posted in May for 1573.26 on May 15th. That check bounced on May 20th, which took that $1,500 into June. Then when you paid in June, you only paid. What did you pay in June? You paid $1,400, leaving a $1,786. So my question to Ms. Fairley.
Well, no, you're not going to do it that way. My courtroom. You don't get to ask questions.
Okay, well, Judge, she was paying $1,400 if she felt better.
What did I just say?
Okay. Your Honor, she's been paying the.
I know.
Right now.
I heard.
Yeah.
It.
You're making the same inquiry that I was trying to make to her outside.
Ma'am, point of fact, you know your rent's not 522 because you paid more than that on a certain month, right?
I paid what I was told to pay because I wanted to stay housed. But Your Honor, I do believe that the document that was given to me, and that I did go over and find paperwork reflects the true rent amount.
Then you need to tell me. If you think that that's it, then how much do you owe?
I have to calculate that.
But ma'am, you can't come in to the court and on the date that we had the hearing and I enter the judgment, you say nothing. You know exactly what I'm going to do. You get apprised of your rights under the court rule. We do all of that. And then later on, after that's done, come back and say, that's not what I owe. And then, okay, and frankly, because of what you filed with the motion, and I probably shouldn't have done it, I let the hearing happen. There was no escrow paid. But I let it happen because you're saying that you didn't owe that. I then get to the hearing and I say, well, what do you owe? And you can't tell me.
Well, I believe I did write down something. And I can tell you that. Allow me to find it.
Allow you to find what?
What I think I wrote down as far as what I believed I owed. It's with my original motion. I only count because LIHTC goes off of calculations on their tables. Those were the only ones that I was able to try to figure out my actual rent, what my actual rent was. Because with my lease, it's supposed to come with a lease writer and a lot of documentation that's supposed to. So it's possible that the amount may be 4,898.
4,898. You have that?
I do not have that today.
Then I'm done. When I granted the judgment, and just so that the whole record is clear, I granted that on November 7th. You would have had until the 17th to get it paid. I extended that to the 1st of December to give you an opportunity. After I do that, almost 2 weeks afterwards, you filed this. I still give you the benefit of the doubt. I set a hearing. And without reiterating what I said before, you weren't able to give me an amount before now. Then you give me an amount of about $4,900. And I ask you, can you pay that today? And you don't have it. I don't see a basis upon which to give you any relief from this judgment. You've established nothing for me. So regrettably, ma'am, you haven't established it. And I'm not, they're entitled to their judgment. They're entitled to have their judgment forced. So the motion to set aside or give relief from the judgment is denied. The writ will issue. And I have it in the file already.
Thank you, Your Honor.
Spice Tree Apartments versus Angelique Dixon.
City Fontanelle for plaintiff, Your Honor.
Good afternoon.
Good afternoon. What's your name?
Angelique Dixon.
All right. And what is plaintiff's claim in this case?
Your Honor, I'm showing that there is rent due of $3,682.75, court costs of $169, for a total of $3,851.75 due.
All right.
Okay, if I can explain, my November rent ended. The total for that was $1,918. I'm a senior at Michigan. Had a couple health scares over the semester, fell behind in my rent. I got approved for emergency funding from the University of Michigan for $1,918. So that's the entire month of November. They had to send that as a check in the mail. So that's still on its way. My prorated rent for December, because my lease ends on Monday.
Okay, hold on, do me a favor.
Yes, sir.
You're a student? What year?
I'm a senior.
You're a senior. All right. You didn't expect to be here in court ever, right? It's okay. All right.
Yeah.
Do me a favor.
Yeah.
Take a deep breath.
Okay.
Slow down.
Okay.
Okay. And we'll get it. I'm not smart enough, so you hear people say all that stuff, right? It takes us Maryland people a bit to follow.
Okay.
All right, go ahead.
I'm talking very fast. So I was approved for University of Michigan emergency funding for the month of November's rent. They had to put that as a check in the mail. I haven't received it yet, but they sent it November 26th.
They're going to send that to you.
Yes.
Okay.
That's on this. They sent it out November 26th. So it should be coming next couple of days, but I haven't gotten it yet.
You have great faith in the mail system, but go ahead.
Yeah.
No, go ahead.
My prorated rent was $675 because my lease ends on Monday. So I've been talking to my landlord about that, and I have the paperwork for like my notice to vacate and everything. So my total, he said over text and email, is $2,750 that's on my account, but it hasn't been adjusted in my payment portal. It says I owe $4,000 after fees. So what I'm worried about is like I can get that. Once I get that check, I can pay it. My prorated rent I can have paid by the 19th. But
start speeding up again.
I'm sorry.
So no. So you're planning on moving out?
I'm moving out on Monday. Yes.
On Monday.
Yes, the 15th.
Your Honor, this is a possession only action. If she vacates, then we would dismiss.
Yeah.
Oh, okay.
I mean, that doesn't mean that you don't owe the money, but
yeah.
Right. But and they're sending the check to you so you can pay them to cover purchase, and you're going to have that balance, but you're moving out on Monday. So here's what I'm going to do. I'm going to adjourn this to December 19th,
okay,
2025 at 2 p.m. Like I said, if you move out, the case is going to be dismissed. Okay? But make sure you turn in the keys. They know that you've left and everything along those lines.
Will I still have access to the payment portal to pay it? Or should it be like
you probably should get that check turned into a cashier's check and get it to their office.
Okay.
So they can put it on your account.
And will the amount be adjusted?
Well, I don't. Go ahead.
Your Honor, I would say I'm not fully sure, but I am guessing that what would happen is once she vacates, they will prorate the December rent and that will be reflected on her ledger. And so then she can make that payment of, the check that she receives. And then there's still obviously going to be a little bit of a balance. And then if she can pay that, then that should square everything away with regard to the past due balance. But she should just communicate with management about that because my office doesn't usually get involved with those things.
Okay, I can do that.
Okay, you got it?
Yes.
Okay, well, what's your major and what are you going to grow up to be?
I'm international studies and I'm actually pre-law.
Oh.
In a year, I'll be in law school.
You're going to be in law school in a year?
Yes.
For God's sakes, why? No, I'm kidding. Where are you going to be going?
Howard, hopefully.
Howard, going out east.
Yes.
Okay. Well,
From
now
Detroit.
I can like you. And the only reason I can like you, I'm a University of Maryland grad.
Okay.
So we're right in the same area.
Yes, I'll be joining that area soon.
That area.
Yes.
Fantastic. Well, young lady, congratulations.
Thank you.
Beautiful.
Thank
All
you
right.
so much.
All right.
Am I all set?
You're all set.
Okay, thank you. Have a
Take
good day.
Really? Okay. Pleasant Lake Park versus Christopher Genoa. 2 cases.
Good afternoon, Judge David Morris for Plaintiff Pleasant Lake Park.
Your name?
Chris Genoviak.
Okay. Genoviak. Sooner or later I'll get that. Did you get the letter that he filed with the court?
I did not get a letter. I understand that Mr. Genoviak told me that he filed something today with the court.
Yes. Can we get a copy? But it's basically indicating that somebody came in to treat for what he's indicating arrest, put the treatment in the vents, and so now there are issues with that. Is that sir, would that be a correct summation of what you had indicated?
Yes, Judge. The maintenance man is not a professional licensed maintenance man. He's a landscaper by trade. And on the 19th, I brought you proof from the licensed and insured inspector that there was a current massive rat infestation. And I thought I was going to get rat treatment like the day or 2 after, but that didn't happen until a few days ago. And then the landscaper or maintenance man, he just poured pounds of rat poison into my vents and clogged some holes. The holes are not fully closed. And after a quick Google search, it said, and after a quick phone call to a professional pest control man, you should never pour rat poison to vents. The day after the day that he poured all the rat poison, it was like a concert in my trailer because the rats are all running around eating poison and dying. it's less quiet, after the rat poison is throughout my vents. But there's still something alive in my vents and keeping me up. This has been going on since August. The problem is way worse since August. If Mr. Weasel would have done things professionally, we would have boarded up the holes in the 30 in a few days, and then we would have found out there was a rat infestation. Then he should have hired a professional rat pest control. This all would have been done by the end of August. But
sir, do you want to move?
I want to move, but I'm not being offered a fair deal, and I don't think I'm going to get my deposit back. I'm in fear of my life. I'm in fear of danger. Mr. Weasel said that I told somebody I was going to shoot somebody, and that never happened. I would like to face my accuser. His inspector, who's my next door neighbor, who's not an inspector, myself, the inspector, and Mr. Weasel, the owner of the park, we were all standing in my living room in a pile of rat poop. We all confirmed it was rat poop, and then that gentleman named Stephen submitted evidence to the court saying there was.
Okay, hold on a minute.
Just lies.
Okay, so usually there are two parts to these cases. There's going to be the possession part, and then there's the money part. Okay, so you want to move, and what I'm thinking is let's get you out of there, and then we'll do the money part and figure that out.
I need to find so my niece. So I don't want to make a stink. I'm not a confrontational person. I've never had problems with confrontation or police. I would like to move. I made multiple deals.
Well, let me ask you this. Hold on a second. When would you be able to move out?
My ideal move out day would be February 31st.
Well,
and I would like to.
That's a day that doesn't exist.
I don't want to cause problems. I'm trying to leave as soon as possible. I've offered to leave January 31st, but
okay.
I need to just,
can you?
But I mean, I've been living with rats.
I know, but that's going to be a money issue. So January 31st would give you enough time to move?
I would, yes, but I can't live with rats. It has to be prorated due to the rat infestation that's been proven with receipts. Yes, I want to leave as soon as possible. I fear for my life.
No, I know that, but what I'm saying is what I was going to do is do a judgment for possession for that day that you can move out. And then you can come back and we can deal with the money part.
So the money is a large variable, is a sticking variable because I don't want to be taken advantage of. And if we could come to some kind of a
but we can still do that. But you're not happy there. They're not happy having you there right now. I'm presuming the council has not said that to me, but I'm presuming that's the case. And so it would seem to me that let's pick a move out date, get you out of there, and then we can deal with what the money is afterwards.
Yes, Judge.
Okay. January 31st. What does plaintiff think of that?
Yes, Judge, that would be agreeable to plaintiff.
Good. So what I'm going to do is I'm going to grant a judgment for possession. All right. There'll be no redemption on this judgment.
I don't understand what those words mean.
That means that you can't pay and stay. It's just going to be you're going to move out. And you're going to move out. They can get a writ to have you move if you don't move by January 31st, 2026. Then I'm going to set a hearing on money damages. All right. And I'm going to set that for, give me a date about, because they're going to have to do their inspection about 3 weeks from the end, 3 weeks into February, or February 31st. Okay. You tell me February 31st, I'm coming over. February 17th? Yes. All right, let's do that. I'll set a hearing on damages, folks, for February 17th, 2026. That's a Tuesday.
Yes, sir.
9 a.m. Okay?
Yes.
So The treatment for rats, that's still like, is that come on, grab the ball or just not?
What now?
So how am I gonna get treatment for rats? That's how I'm gonna.
Well, I think we need to get you out of there because otherwise I'm gonna have to hold a hearing on it. So if you don't find that acceptable, then you might want to talk to somebody about what would be a good way to treat for the rats.
Your Honor, if I may, we are working with Chris on his concerns, and we've taken steps. The rat poison was at his direction, and now he's complaining of his own directions. But
that was not my direction. That was the landscapers. The landscapers doing pest control unprofessional. Well, I had no leadership in all the rat variables.
The fact remains, Your Honor, that if Chris wishes to do repair and deduction work with the pests, then certainly that is more than agreeable to the plaintiff.
I don't want to cause damages.
And that would be factored into any money judgment one way or the other.
The damages are done. The holes are plugged. There's rat poison fumes and dead rat fumes blowing.
All right, but what they're saying is that if you want to do something, then we'll figure that all out.
Yeah, I just don't want to cause. I'm not trying to make a stink.
Pardon?
I don't want to make a stink. I just want to get out of here clean, properly, and I don't want to touch it. I don't want to be accused of anything.
Okay.
I'm a smooth cat, so I'm trying to get out all 10 toes.
All right. So what we'll do is I wish you both happy holidays. We'll see you in February. February 17th.
17th. Okay.
9 a.m.
Yes, Judge. Thank you, Judge.
All right. Thank you.
See you, Mr. Allen. Thank you for your service.
Thank you, Judge.
Thank you. Thank you. Thank you for all you do. All right. Thank you, counsel.
Thanks, Judge.
Oh, and ladies and gentlemen, that's how we leave it. With Judge Simpson, head in hand, laughing away the rest of his day because nothing, ladies and gentlemen, nothing was as frustrating as that was for the rest of the day. It was an interesting day in court, and I hope you enjoyed my presentation of some of the best cases that I saw today as we were watching the court cases from around the country. Thank you for joining in with me. I'm your Lone Wolf Uso. I'm your humble host and curator for these here videos. Come on by to the court gallery tomorrow, Saturday. That would be December the 13th. 2025. We'll be live again at 11 a.m. Central Time. That's noon Eastern Time. And I have a whole nother set of Simpson ready for you, ladies and gentlemen. Boy, did a fun one. Come on by and we'll see what we have in store. I believe it's actually Simpson and DeSanta. Some of you may have already seen some of the cases, but it'll be time for us to talk about it together. Ladies and gentlemen, thank you so much for participating in chat and making chat so great as you always do. I'm here every night of the week, same Wolf time, same Wolf channel. I hope to see you next time. We'll see you. I'm Wolf, and I'm out. night, all.